I'm Heidi Jeffrey, a partner with Foley and Lardner. My practice is based out of our Chicago office. I'm an experienced bond lawyer serving as bond counsel and counsel to various borrowers in bond transactions. And I focus my practice primarily in healthcare finance and public finance. I'm pleased to welcome you to today's webinar conference titled The Effects of the Tax Cuts and Jobs Act on Hospital Financing. Presenting with me today are my partners Mike Bailey and Dave Bannard. Mike is a partner and business lawyer in Foley Chicago office, and his practice focuses on tax advantage financing, including tax-exempt financing and tax credit transactions. Mike joined the firm from the Internal Revenue Service, where he served as counsel to the Assistant Chief Counsel for financial institutions and products. He was one of the principal authors of the major federal income tax regulations concerning tax-exempt bonds, including the arbitrage regulations and the private activity bond regulations, and he reviewed or authored most other administrative guidance issued by the IRS on tax-exempt bonds from 1990 through 97. Mike is currently the chair of our firm's healthcare finance practice. He is past chair of the IRS Advisory Committee on Tax-Exempt and Government Entities. Dave is a partner and business lawyer in Foley's Boston office. Dave is an experienced bond lawyer, having served as bond counsel and counsel to various parties to bond transactions, including borrowers and underwriters, and in-house issuers counsel. Dave focuses his practice on transportation and healthcare finance. Before I turn the presentation over to our speakers, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour and 15 minutes, followed by a short question and answer session. For those of you who do have questions, please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. The presentation is currently available to download under the resources, and the recording will be posted on Foley.com in the next few days. CLE credits are being offered for this program. We will be announcing the 5-digit code at some point during the presentation. Those seeking Kansas, New York, and New Jersey CLE credits are required to complete the attorney attestation form. Enter the 5-digit code that will be announced during the presentation on the form and return the form to Kristen O'Neill at Foley.com, KONEILL at Foley.com immediately after the program. And now we will turn to the agenda for today's program. Today we're pleased to provide you a discussion covering the provisions of the Tax Cuts and Jobs Act relevant to healthcare finance. We'll be discussing ongoing risks of tax law change. We'll be discussing the implications of the reduction in the corporate income tax rate, and we'll also cover the implication of other provisions of the Tax Cuts and Jobs Act. At this point, I'm pleased to turn the presentation over to my partner, Mike Bailey, to begin. Thank you.
Okay, thanks very much, Heidi. Of course, the Tax Cuts and Jobs Act was signed on December 22nd, 2017, and has been effective since January 1st. And many in the healthcare finance industry, I think, view it sort of like a giant asteroid that had a near miss from hitting planet Earth, and it did pass by, and everyone breathed a sigh of relief that it didn't cause a complete extinction event. But it did leave some fragments that did hit Earth, wipe out certain regions, and also, I would say, sort of change the climate. So we're going to focus on now on the apparent changes that the Tax Cuts and Jobs Act has had, sort of survey the wreckage from what's happened, but also discuss some of the more subtle changes that may arise from the Act, sort of the change in the climate that has resulted. So, I know there's been many presentations by different law firms and others on the effect of the Tax Act in different industries. And, even in the tax-exempt bond industry, the Tax Act has different effect on different segments of the bond industry. And so we're proposing to focus in particular on effects on 501c3 finance as compared to effects elsewhere in the tax-exempt bond industry, and spend a little bit of time talking about what's unique or different about 501c3 finance as compared to other tax-exempt finance. So, as I'm sure most of you know, one of the major changes was that the Act repealed the authority to issue so-called tax-exempt advance refunding bonds. And advance refunding bonds are defined as refunding bonds that are issued more than 90 days before the refunded bonds are redeemed. The Act also repeals the authority to issue tax credit bonds. Some 501c3 borrowers have dabbled in tax credit bonds, but they've generally not been very significant for this part of the industry. Of course, the proposed repeal of the authority to issue other types of qualified 501c3 bonds was not enacted. And, of course, the maximum tax rate was reduced to 21%. Now, these are just a few of the many provisions which have impact on healthcare finance. We're going to discuss a number of others. We're not going to discuss as much, the repeal of the individual mandate, for example, but really focus on provisions of the Tax Act that are expected to have an effect on healthcare finance. Just a word about the effective dates. And for different provisions, the effective dates of the Act are slightly different. For advance refunding bonds, the repeal applies to any bonds issued after 2017, so no 501c3 advance refunding bonds can be issued any longer. The change in the federal corporate tax rates has a somewhat different effective date, and it's applying to tax years beginning after 2017, which could have some effects this year, and we'll discuss that more later. Just to note that many of the proposed provisions in the tax legislation had been proposed many times before, and the Congress has many times taken action to limit or propose to further limit advance refundings. Of course, going way back to 1986, there were provisions that generally limited the number of advance refundings to one. So there's nothing really surprising that Congress would enact this provision when they were seeking pay-fors or revenue. It's a proposal that's been made many times before, and the IRS has always, or the Treasury, has always been somewhat suspect of advance refundings anyway. But what does it mean that the repeal of advance refunding bonds is one of those provisions that's been proposed many times before? I think it also arguably sets a bad precedent that changes that have been proposed many times may be more likely to be enacted. And of course, Congress has also proposed many times to take away the ability to tax-exempt finance for 501c3 organizations. So, what are some of the immediate effects on the elimination of advance refunding bonds? One is that, it may lead some borrowers to consider shorter call protection periods. That is, revisit the common 10-year call protection period. We've already seen that. a major state just issued bonds with a 5-year call provision. It may prompt revisiting the premiums paid related to calls and so forth. It's uncertain how that's going to play out. Just as a purely technical issue, it's often been the case that in structuring healthcare bonds in particular that may have variable rate and fixed rate components, they've often been structured to be separate issues for tax purposes. That whole question of whether you need to take action to separate a large bond issue with fixed rate and variable components into different bond issues is likely changed by the elimination of advance refundings, because one of the reasons to keep fixed rate bonds separate was to facilitate advance refundings. But one thing we wanted to talk a little bit about is how the experience with many other types of bonds that have long been ineligible for advance refundings may inform how the industry will respond to the repeal of advance refundings for 501c3 bonds. So, for example, many of the other so-called qualified private activity bonds, many of the bonds for airports, the bonds for residential rental housing, and so forth, have long not been eligible for tax-exempt advance refunding. And yet we haven't seen so much a wave of different provisions for those types of bonds. So one question is, will 501c3 bonds simply follow that model, or is there something different about 501c3 bonds that may result in different experience? So a number of proposals have been considered over the years for sort of alternatives to advance refundings. The National Association of Bond Lawyers released a paper on this that I thought was pretty informative, and they listed many of these same alternatives: taxable advance refundings, Cinderella bonds, forward delivery bonds, swaps, negotiating with existing bondholders, sale of optional redemption rights, and so forth. But when I'm thinking about these alternatives, I think it's important to step back and consider what are the purposes of advance refundings to begin with. And of course, one obvious purpose is to result in reduced interest cost and the financial benefit. But that's not, of course, the only benefit that's often sought by tax-exempt advance refundings. Others are just debt service restructuring, even if there isn't savings. And a third is, of course, defeasing debt in order to change bond covenants or facilitate other types of transactions. And of course, many of these alternatives to advance refundings accomplish some of those purposes and not others. And just looking at this list, forward pricing bonds, interest rate swaps, and so forth, can result in interest rate savings, but they wouldn't accomplish defeasance, whereas some of these others that we list that involve defeasance, for example, taxable advance refunding bonds, could achieve both goals. So we were going to discuss at greater length what these alternatives are and how they may play out in the 501c3 industry. First is forward pricing bonds. It's not been that uncommon for bonds to be sold a long period of time before they're actually issued. And for example, if you had some bond issue that couldn't be actually redeemed until June 1st, 2019, an issuer might enter into a forward agreement to actually issue the bonds, say, in May 1st, 2019. So you would have a long period of time between when the bonds are sold and when they're issued. That type of transaction has not been uncommon. It's often the case just because of the yield curve that that forward rates, the rates to sell bonds a year from now, are of course often higher than current rates. But I think one thing to consider is that there is a risk of tax law change, particularly in the 501c3 area, that could continue to be a factor. Another proposal has been swaps, and actually various different types of swaps. We don't explain in the slide the different types of swaps. Some of the swaps are basically just intended to lock in current rates, the so-called rate lock swaps or forward starting swaps, which basically have the effect of locking in fixed rate now or the forward fixed rates for a future transaction. Actually, that path for how forward starting swaps are treated for tax-exempt bond purposes is very well worked through in the regulations. There isn't, in my view, much of a problem in dealing with the tax law issues. The complications more tend to arise because swaps are inherently more complicated than, for example, a forward pricing of bonds, and require another transaction that may be complex. But they can have other benefits for those borrowers who are prepared and willing to deal with their complexity. Some of the swaps, I know particularly the so-called total return swaps, have been treated by the IRS as resulting in reissuance, so there's always a question about whether certain of the more unusual swaps have unexpected tax effects. Taxable advance refundings. In my experience, they've been rare except in the circumstances where a borrower needs to defease its debt to change its covenants. They do tend to be less cost effective because it's difficult to issue them without significant so-called negative arbitrage. The difference between the borrowing rate and the rate in advance refunding escrow is invested. If I will note that if there's private use issues or compliance issues, if properly documented, taxable advance refundings could have the benefit of basically cleaning up prior bond issues that may be perceived as having other tax problems. And there's also a number of considerations that may apply to whether borrowers issue taxable debt directly or through a government issuer. I did want to mention, too, not in the slide, the so-called Cinderella bonds, which in recent days have attracted a lot of attention. The thought that these bonds that would be taxable for a period of time and then convert to tax exempt. So, for example, if there was a bond issue that wanted to refund a bond that couldn't be called until June 1st, 2019, you'd have a taxable interest rate until June 1st, 2019, and then flip into a tax-exempt interest rate. This type of structure was discussed at some length at the conference of the bond lawyers just last week, and a Treasury official said that he didn't see any problem with the so-called Cinderella bonds, provided that the pricing was correct, and that is if there's a single purchaser entering into both a bond that has a tax-exempt rate and a subsequent taxable rate and a subsequent tax-exempt rate, there's a risk that the tax-exempt rate could be stated as too low and the tax-exempt rate stated as too high. And he indicated that if there are such transactions which sort of distort the tax-exempt rate and make it too high, that the Treasury and the IRS would likely challenge those transactions. So one takeaway I have is that the so-called Cinderella bonds are a viable alternative, but the difficult question is making sure that you're able to document that both pieces of the transaction, the taxable piece, the initial taxable piece, and the subsequent tax-exempt bonds are independently fair value, and they independently stand on their own because, after all, the idea is that even though it's one bond for some document purposes, it's treated as two bonds for tax purposes, and that the tax-exempt bond isn't treated as issued until a later date. Acquisition financing, as you may know, there's special rules for when debt is refinanced in connection with a merger or affiliation that's treated as an acquisition of assets. This has been a particularly important provision in healthcare finance as systems have merged or as large systems have acquired smaller systems or other hospitals. When the debt of the acquired entity is refinanced in connection with the acquisition, that refinancing can be treated as not a refunding at all, but rather as a new money financing. And so, in substance, acquisition financing is really, in financial substance, a synthetic advance refunding, if you will, or the equivalent of an advance refunding, but it's not treated as such. So our perception is that acquisition financing will continue to be more important than ever in healthcare finance in connection with affiliations. One of the key rules is that there has to be a refinancing within 6 months of the merger or acquisition closing date. There are a variety of special rules that apply to acquisition financing that the industry has worked through, mostly based on regulations drafted around 2001. So there's been a lot of experience with acquisition financing. In our view, the framework for acquisition financing hasn't been adversely affected by the Advance Refunding Repeal, and indeed, acquisition financing has become more important than ever. Now, we said we were going to talk about some aspects that may be somewhat unique to 501c3 finance, and I would put these defeasance transactions in that category. And in the past, there have been a number of transactions by major healthcare borrowers where debt has been defeased by cash, and then subsequently, or sometimes previously, there have been new money bonds issued in a roughly corresponding amount, and with results that sometimes have been characterized as getting to a result that's equivalent to an advance refunding. So, for example, you have a hospital that has $100 million of bonds outstanding at a high interest rate, and ordinarily or previously it would have advance refunded those bonds, and also could finance $100 million or $200 million of new money expenditures. It may defease its bonds with cash, and then a month later or 2 months later or some other time later issue $200 million of bonds for new money expenditures. And even though it otherwise might only have issued $100 million for new money expenditures. So those transactions actually, in some respects, can look a lot like advance refundings if you were to combine them. And the key for making them work is that the defeasance transaction, whether the defeasance transaction occurs before or after a new money bond issue, has to be treated separate from the new money bond issue. And there's no regulations that specify how you separate a defeasance transaction from a new money bond issue. It's all based on sort of general principles of tax law and so-called step transaction, whether you treat two separate transactions as the same. So to the extent a borrower can say, well, I'm defeasing my bonds now. It's not part of the same plan of finance as a subsequent new money issue. they're in a much sounder position than if you have an overall plan of finance that closely links a defeasance transaction from a subsequent tax-exempt bond issue. So is this sort of defeasance transaction going to become more common? And I think it likely will be, or at least there'll be many proposals to do different variants of these defeasance transactions. And so what is different about 501c3 finance from other types of bonds? Well, of course, governments, state and local governments, can't do advance refundings, but generally they don't have the financial wherewithal to come up with the cash to defease their debt. Many large exempt organizations do. So that makes them unique. So you may see this sort of transaction in the 501c3 area when you wouldn't see it at all for state or local governments. The other issue is that many other types of qualified private activity bonds are subject to so-called volume cap. So you might not be able to issue more new money bonds. So this is actually what I see as one of the key issues going forward is how borrowers respond to these defeasance transactions. Do they adopt policies or procedures, or do they think about how to structure their financing plans so that they can be sure they can take advantage of benefits of being able to defease their debt without having it being viewed as abusive? And so we have been, working internally on what sort of policies or procedures or approaches we think would be most suitable to avoid the pitfalls of this particular type of approach. Again, it's nothing new. Many of these transactions have been done in the past, but with the repeal of advance refundings, I'm sure there will be pressure to do more of them.
Mike, it's Heidi. If I can jump in here, it seems to me that of the different alternatives you've laid out, the use of the taxable product or this defeasance concept will probably, I would think, emerge as two of the more viable candidates. On the defeasance approach, it seems, yes, where do you come up with the cash, whether it is actual cash or commercial paper. Coming up with the cash is certainly an issue, but it also seems to me that just your corporate approvals, the timing of the corporate approvals, and the optics of joining together the approval for the defeasance and then the subsequent approval for the bond, that becomes an important consideration in addition to the policies and procedures that you're talking about.
Right, and I know, just to be very candid about this, over the years, I know there are, borrowers and investment bankers and financial advisors on the line and so forth, but it's not helpful if an investment banker comes to a borrower and say, oh, here's how you can do a synthetic advance refunding, and presents a financing plan for a synthetic advance refunding, because that is sort of creating an invitation for the IRS to view the transaction as abusive. On the other hand, I don't think there's anything wrong in substance with the borrower for its own financial reasons, defeasing its debt, and then issuing other bonds for new money debt. One wrinkle to this that may become important is that there's a special regulatory rule in the reimbursement regulations that says if you do a reimbursement bond and you reimburse $100 million of expenses, and within a year you set up basically an escrow in a corresponding amount, like you created defeasance escrow for $100 million, they'll say there's an anti-abuse rule that says they can treat that new money bond that reimbursed as being used for the refunding escrow. So strangely, I think it's bad policy, but there's a particular rule that could be problematic if you do a reimbursement bond and then do one of these defeasance bonds within 1 year after, or this defeasance transaction within 1 year after that. So that's one example of some of the complexities that may arise. I think it's really, we don't have time to get into all of the particular facts and circumstances that may be relevant to this, and because it's really based on general principles, I think different counsel will have different views, but the basic idea is, how can you be comfortable that the IRS will respect a defeasance as being separate from a bond issue that may be issued in a nearby period of time? And you can sort of see there could be any number of facts and circumstances that would tend to link the defeasance to another bond issue. And you want to think about how, if you're going to do one of these, you make certain that there aren't too many links for your defeasance to a bond issue that's either done before or after. And, that's also substance as well, that you're taking steps to make sure that they're separate, and that's because otherwise I think they're entirely legitimate transactions unless you're sort of linking a cash defeasance with a bond issue.
So Mike, this is Dave Bannard. I'm going to jump in here and bring in a few examples from outside the 501c3 world. And I have worked on a cash defeasance that was related to the divestiture of an asset by a transportation entity. So when the asset was divested, there were still outstanding bonds that were allocable to that asset. And fortunately, the issuer had sufficient cash to basically cash defease those bonds at the time. And even though the issuer was a relatively frequent issuer in the market, we were able to document that pretty carefully and pretty logically, that when this transportation asset was transferred to another entity, the bonds were called pretty much simultaneously with that transfer with cash, and then some months later the entity went out with its essentially regular bond issue for its capital program. And that's an example of a way that I think these cash defeasance transactions can be entirely legitimate and documented in a way that I think we believe that would satisfy the service.
Yes.
A couple other.
I think they are going to be. You mentioned with a governmental issuer. In my experience, they've been largely a creature of the big 501c3s because they tend to have the wherewithal to do it.
Right.
But I think they're entirely legitimate transactions, but they're full of pitfalls. So it's important to think through, how you're careful to separate the transactions and make sure they be respected as separate.
So I was going to bring in a couple of other things. As you mentioned, Mike, the state of Wisconsin earlier this year did a bond issue with a 5-year no-call period rather than the somewhat traditional 10-year. And at least the early press seemed to indicate that there was sort of a minimal, if any, impact on their interest rates, which it's interesting. And I think what we're going to see is that there are going to be issuers that do try some of these alternatives to see, what the market impact is, and try to, what basically they're doing is seeing what the cost of that 5 years of call protection is worth. Another experience that I can kind of bring in is from the airport experience, where the airports often issue both governmental purpose bonds for certain of their facilities as well as private activity bonds for airport facilities. And so in that context, I have seen forward delivery bonds done, as Mike noted, that there is there's both the risk of change in tax law as well as typically a premium because you're locking in an interest rate sometime down the road. But in certain interest rate environments, that can be helpful. And the other thing that I noted in that context is that the AMT bonds will also often be the ones that we kind of play with when we've got the dual issue going out, because those are the ones that bear some sort of a premium because of the AMT, as well as have certain kinds of restrictions. The last thing I wanted to note on this is that we have seen taxable advance refunding bonds issued, and as Mike noted, that's most often in a situation where you see a combination of healthcare systems, and a lot of times it's not an all or nothing proposition, because many times you'll see that some or a large portion of the bonds may be callable on a current basis, so that you're only advance refunding a portion of the bonds. So the blended interest rate is not entirely prohibitive, and it allows the system to operate under a single set of covenants. I lied. I have one more observation, which is that especially in a situation where there's one or a few holders of the bonds, a negotiated rate change is often possible in that situation. And in that case, it is treated as a current refunding, so that although one has to obviously bear in mind the change in tax law risk, if you are in a direct placement, and we'll talk about these a little further on, it may be possible to negotiate with the holder of the bonds to restructure the interest rate as a current refunding, which gets around the advance refunding prohibition.
Yes. So I think these various different proposals that have been put forth as alternatives to advance refundings have been used and proposed many times in the past. I would say, each of them has been used, but they're not particularly frequent. And again, the question is, will we have the same experience with 501c3 bonds and healthcare tax-exempt bonds, or is there some reason to think, the experience we'll have with 501c3 bonds may be different? So in that same vein, we wanted to move to the next topic, was the ongoing risks of tax law change. And this is another area where I think 501c3 bonds may be unique, or at least distinguishable from governmental bonds. Because even back at the end of last year, after the Tax Cuts and Jobs Act was finalized, some of the leading congressional Republicans suggested that they wanted to revisit legislation affecting qualified private activity bonds, perhaps in the context of infrastructure legislation. Who knows how serious these statements are, but a number of the leading Republicans have made these statements both in December and subsequently. Senator Toomey made some particularly strong statements about revisiting private activity bonds in 2017. There doesn't seem to be any of the same sort of discussion about revisiting the authority to issue traditional tax-exempt governmental bonds. So our perception is that at least qualified 501c3 bonds, taxable hospital bonds, are at more risk of adverse tax law change than, for example, governmental tax-exempt bonds. So there may be different approaches to deal with that ongoing risk in the hospital finance area than there would be in the rest of the tax-exempt bond industry. So, one recent development are these infrastructure proposals. This refers to the outline released on January 23. There was a subsequent, more detailed legislative outline that was released in February, which actually proposed different sorts of new sort of public-private partnership qualified private activity bonds. None of those new types of bonds that were proposed by the administration would include 501c3 hospital bonds. And there's no discussion in that legislation about paying for an expansion in infrastructure bonds with 501c3 bonds, but that is a risk many of the industry have been concerned about, that they're talking about new types of tax-exempt bonds for infrastructure that would cost about $6 billion, and would they use the repeal of hospital bonds to pay for that? So that's perceived to be risk, although there is nothing in the more detailed proposals that have recently been released about how the infrastructure legislation would be paid for. Of course, in the past several days, some of the leading Republican senators have been quoted as saying they don't expect any infrastructure legislation this year. Who knows? But within the next year or so, or a year or two, something may get picked up. So I think there is a realistic risk that continues. Maybe another fragment from the asteroid will hit the Earth. You never know. And so how does the industry respond to that? And one question is, will there be another rush to market? I think it's not impossible. It's not as as likely as it was last year, I think, when we were facing tax reform legislation, but it exists. And are there ways to structure or restructure bond issues to sort of insulate tax-exempt bonds from the risk of tax law change as much as possible? And one concern that was raised under the last rush to market at the end of 2017 is that the proposed repeal of 501c3 bonds had no grandfathering rule for current refundings of existing tax-exempt bonds. But it was perceived that if you could change the interest rate on a tax-exempt bond without having a reissuance or new issue for tax purposes, you might be grandfathered. So one particular structure that we saw emerging at the end of last year was for bonds that would ordinarily be issued as a fixed rate, would go out in a basically a fixed rate mode that could be converted under the terms of the documents to a different mode after 10 years or after a call period. So from a buyer's point of view, not much different than a callable fixed rate bonds, but from the issuer's and borrower's point of view, perhaps a structure that could be better insulated from tax law change. So one question we have is whether these more complicated structures, which basically are intended to insulate from tax law change, will continue in the 501c3 area. I think that's a real question. I think there's reasons to consider these more complicated structures to sort of buy insurance against tax law change. I think it's a type of structure we will not see in governmental tax-exempt finance because the risk of tax law change is so much less for traditional governmental bonds.
Mike, it's Heidi. Sticking with that theme, why, if I'm going out with a bond issue this year and there continues to be uncertainty, why wouldn't I, and I want to issue fixed rate bonds, why wouldn't I elect to issue those under a multimodal indenture, an indenture with some more complicated structures within it? What are the disadvantages that you see?
Well, it's a if nothing else, the bond documents are more complicated. The disclosure of the whole reissuance structure is more complicated. There are some very technical issues because you might have what's treated as a variable rate issue for tax purposes rather than a fixed rate issue, which might be a little bit more complicated from a tax analysis point of view, but I would view those tax issues as being mostly a technicality. So, provided that there's no adverse reaction in the marketplace to these structures, it's probably a small, relatively modest cost for some insurance against tax law change that the risk may not be high, but the cost of the insurance is not that high either. So, I think it's really a weighing that borrowers would have about whether they want some additional complexity for some degree of insurance against tax law change.
Mike, this is Dave. I will jump in there to say also that we did see quite a lot of those deals being done toward the end of last year, and some of those were done as sort of shorter-term direct placements to allow a remarketing. And one of the things that was built in, just to be kind of explicit about it, was an ability to have a long-term interest rate that wouldn't necessarily go all the way to the term, or was at least convertible after a certain period of time. So much like a no-call period, you could issue long-term rate bonds that would bear interest over a period of time that could be as long as the final maturity, but there would be an ability to convert the bonds into another mode after a lockout period, for example, which is very much akin to allowing a current refunding of some sort. So it does give sort of some of the benefits of being able to maintain the tax exemption while being able to current refund at some point. The other point I wanted to make is that for those entities that have a drawdown bond structure, and I know that that's not all that common, but we certainly have seen that with a number of issuers. Each time the bond is drawn, it's subject to any change in tax law. So a tip on those would be to make sure that the documents allow the borrower to draw down on a relatively short amount of notice all of the undrawn proceeds if necessary. That's one way to protect from this change in tax law risk so that you don't find that you're kind of stuck.
Right, and I just noted that all of these approaches are just our best guess at what may work in the future, because after all, the tax law may change. I mean, they could write a new legislation that says, anytime you change the interest rates, you have a new bond issue that doesn't qualify. They could write new legislation that way. They could change the rules for what is or isn't a reissuance. And indeed, the IRS has been talking about revising its rules for what is a reissuance. It's on the business plan this year. So there's no certainty about what will or won't be a reissuance, and whether these approaches to avoid, having a refunding but having a grandfathered bond that isn't reissued will work. But it's our best guess at what can work right now. And indeed, just a few sort of high-level observations. One is the so-called direct purchase bonds, which are purchased directly by a bank or treated as bank loans, are just inherently subject to a greater risk of reissuance because of the way they're structured. Traditional publicly offered multimodal bonds, at least under current law, avoid much of the reissuance risk. They're sort of a very clean approach, and now we're beginning to see sort of hybrids of the two. So just a question moving forward about whether the complexity to avoid this risk as much as possible is worth it, and I think generally it may be. So, anything else on that point, Dave or Heidi?
No, I think we covered that well.
Okay, why don't we move on? And then, so of course, another big change is the reduction in the corporate income tax rate, which is expected to have a large number of effects. One of the perceived consequences is that banks and other financial institutions may be less competitive purchasers of tax-exempt bonds than they have been in the past, because if they're taxed at 21% rather than 35%, they'll get less benefit from the tax-exempt income. And whether that means banks will recede from the industry or just be less competitive, or maybe they will be as competitive, I think remains to be seen. It's sort of like how the climate changes from the asteroid. We haven't seen that, but there's definitely a change, and the players in the industry may change. So what does that really mean? If banks are less competitive, it may be that more transactions are publicly offered than in recent years if the banks don't play as big a role, or will there be other purchasers who will step up? Will there be greater use of publicly offered variable rate structures, for example, going back to the the old lower floaters with letters of credit or not, I think remains to be seen, because after all, direct placements were often used as a cost-effective way to get variable rate exposure. So, we'll have to see how this plays out. There's been some discussion in the industry of sort of hybrids. Basically, banks may acquire bonds and then participate them to investors who can take advantage of retail investors who can take advantage of tax-exempt finance in light of a 37% tax rate. But those structures themselves, as sort of hybrid structures, have a number of issues that have to be worked through as well. So however it plays out, there will be changes in the industry that will be significant. Of course, one of the hot topics in the tax-exempt bond area have been the so-called interest rate step-ups that are contained in many direct purchase bonds that basically have been in many direct purchase bonds for the past 10 years in various different ways, and they generally state that if the interest rate, the maximum corporate income tax rate, is reduced, the interest rate on the bonds would be or could be increased by the bank in a manner to compensate them for the reduced benefit they get from their lower, from the tax-exempt financing. So the typical step-up is based on a formula that basically takes into account the reduction of the maximum rate from 35 to 21%. It results in a step-up of about 1.21 or 1.22%. So if you had a 2% bond, it might go up 0.4 or 40 basis points thereabouts. And interestingly, it appears that these types of interest rate step-ups have been particularly common in healthcare and 501c3 finance, but many banks are currently assessing how to respond. And even though many of them have provisions which could have taken effect as of January 1st, many banks have not yet sent out their notices regarding whether the interest rate will be adjusted. I think part of that is that when you really look through these interest rate step-ups, they take many different forms. Actually, it's quite surprising when you look through the various documents how many different formulations of the interest rate step-up there are. So, for example, some of them have the interest rate step-up in the bond itself, sometimes in a separate agreement. Sometimes the step-up is automatic, or sometimes it's effective only after notice is provided. Sometimes it's unclear exactly when the step-up is effective. Sometimes the step-up says it can be reduced by countervailing federal tax changes. So some of them are relatively straightforward and formulaic. Some of them raise a lot of questions. And perhaps that's one reason some of the banks are being careful about how and when they impose the step-up, or whether they impose the step-up. There is a tax issue that's been much discussed about, basically the idea is you have a new bond issue or a so-called reissuance if you renegotiate the deal. So if a bank and a borrower get together and say, oh, well, we had this step up that would otherwise increase your interest rate by 40 basis points and we're going to agree to waive that, that would likely be a renegotiation of the deal that would be treated as a new bond issue or a so-called reissuance. And the consequences of reissuance aren't necessarily fatal or even problematic, but it would involve some cost. Generally, a new tax opinion is required, usually some additional due diligence to support the tax opinion. The governmental conduit issuer typically needs to get involved, at least to file an 8038 and in some sense approve the transaction. You can sort of create additional bond issues if you're waiving a step up for part of bonds that have previously been treated as part of a bigger bond issue. You could create additional reporting requirements. So there are some costs about having a reissuance. But I think our view is that in many cases, you have sort of tax transaction costs for reissuance, but they're very frequently dwarfed by what's at stake in the increased interest cost. So I think, it's important for us as lawyers to alert, the others, the borrowers and the issuers and the other professionals about this reissuance risk, but it's ordinarily manageable, and the costs may be relatively small compared to what's otherwise at stake. There's been, some question about what happens if a step-up is waived for a period of time, and generally we have this 25 basis point rule that if the interest rate changes more than 0.25%, you have a significant modification, which is treated as a new bond issue. But the test is really applied not on a yearly basis, it's applied over the remaining term. So if you had a 10-year bond and you waived the interest rate step up for several months, it's almost certain not to result in a 25 basis point change over the remaining term. So there is some perception that it would generally be possible to waive or change the interest rate step-up provision by agreement for some period of time without creating a reissuance. But if some of these changes were made for the entire remaining term of the bond, there likely could be a reissuance. So that's just one point to observe. And this may be an important factor really in how banks and borrowers work out these situations, that there may be a period of time where they can agree that the step-up won't be imposed, that won't result in these additional transaction costs until a final deal is worked out.
As Mike mentioned, this was a very big topic of discussion at the recent Bond Lawyers Conference, and it was interesting to see the real range of issues presented. One person said that her borrower client had a bank that said, well, we don't want to make this much money off of the transaction. We don't want to see the step up in the way that it had been set up. And in fact, there are, depending on the way that the step up is drafted, it can in fact result in a step up beyond what might be the current market rate. And so there has been a lot of discussion. I think a couple of things about that is, as Mike mentioned, a waiver for a few months is not likely to be a significant change. In other words, a 25 basis point change over the life. But if your documents call for an automatic step up and nothing is done, it may be that depending on whether or not there's an affirmative waiver or if the bank just does nothing, it may or may not be deemed a reissuance. But it's probably worth making sure you check your documents to see whether or not there is this step-up provision, and if so, how it works. Those are often in a continuing covenants agreement. They may be in the bond or note itself that was issued to the bank, and sometimes they'll show up either in a trust indenture or the loan agreement. But it is definitely worth knowing what you've got on your hands. I do think that it's the banking industry has not yet made up its mind how to approach this, and it's really being dealt with differently in not only different banks but in different markets and in different sizes of banks. I saw one headline that I'm sure was the bank's worst nightmare that said, banks get massive cut in tax rates and hike interest rates to borrowers. I think that's exactly what banks are trying to avoid. And as many of you as borrowers know, you are extremely good customers of these banks, and they're looking to maintain a good relationship. So the best advice, I think, is to get on top of this, know what your documents say, and engage in some dialogue with your banks. Because as Mike said, at this point, a current refunding through a negotiated settlement is not only not fatal, but is of relatively minimal import given what could be a fairly significant uptick in interest rates.
I think, Dave, you've just hit on a lot of excellent points. Namely, we haven't heard the last on this topic, and I know I've received calls from clients saying, gosh, we've heard that our peer hospitals have received calls from our banks, but we haven't received a call yet. Are we, in the clear? And I think the answer is no, that certainly a lot of these conversations are going on, and we anticipate that they will continue to go on. I think, Dave, your point about getting your arms around, if I'm a borrower, I think getting your arms around your bank documents and taking a look at the indenture, taking a look at the continuing covenant agreement, taking a look at the bond, to get your arms around where the increased cost provisions are, if they are there, and what flavor they're in, is a very important first step. And, getting, I guess, one step closer to the documents, I think we've had a lot of discussion internally as to the difference between an increased cost provision that might be in a bank document compared with a step-up provision. And there are differences in those types of provisions, and I think we've taken the view that an increased cost provision needs to be viewed differently than a step-up provision, absent a different intent. So again, I think just a great starting point is pulling out your transcripts, pulling out the relevant documents, and getting your arms around what your documents say, because I don't think that this topic is finished, and as I think we've experienced, a lot of these conversations include some negotiations and careful review of formulas to the extent that there are formulas involved.
Yeah, and Heidi, you make a great point about increased cost being different from a tax step-up. Just for those who may be wondering about the shorthand, increased cost provisions are typically a provision that says if the government increases our cost to making this loan to you, for example, through additional reserve requirements or something through Basel III, then we will pass those costs along to you so that our economic impact is essentially the same. That's very different from a provision that says if the tax rate, the corporate tax rate changes, here's the formula by which your interest rate will change, which can be calculated as a very specific rate, or it may be couched in terms of if the corporate tax rate changes so that it goes down. It's typically never going the other way. But if the corporate tax rate is reduced, then we reserve the right to increase the interest rate commensurately. Those are different concepts from additional costs and tax rates, even though they're both based on the economics to the bank. And we take the position that the change in typically, I think we feel like the change in the tax rate would not necessarily be considered to be an additional cost. So it's worth, understanding exactly how your docs read.
Okay.
We should probably move on.
Yes. Yeah. Okay. So we did want to touch on implications of other provisions in the Tax Cuts and Jobs Act on healthcare finance, and of course there's many provisions that we haven't talked about, and indeed we only have time to talk about a few that will have ancillary effects, and I'm sure that there'll be some surprises that the industry will be affected by various provisions that aren't really expected right now, but we wanted to list a few. And the first ones is I'd sort of describe as the camel's nose under the tent. Many in the exempt organization industry had a lot of concern that a number of the revenue raisers in the Act were really directed at raising revenue basically from large exempt organizations in a way that might not have been dramatic or that in the big picture adversely affecting finances that much, but created a precedent that the Treasury might in the future go after exempt organizations to reduce some of their tax benefits or to raise revenue from them in other ways. So in particular, in the vein of the camel's nose under the tent, are these changes adverse to exempt organizations include a 25% income tax on annual compensation over $1 million for basically the 5 highest paid employees in any year. And once you're one of those 5 highest employees, the act is written so that you stay there. So it's actually a provision which might not have that financial impact, but will get a lot of attention from executives, I'm sure, that will get questions about this provision. There's a provision that makes the UBIT rule stricter, and basically it says you have to compute unrelated trade or business for separate business activities, separate trade or business activities. They've not really defined what that means, but basically it means that large exempt organizations can't offset income in one area by a loss in some other area, which has been fairly common among a number of large exempt organizations. It's not clear how that is going to play out, but it could be significant. There's a 1.4 excise tax on investment income of large university endowments, which under the related party rules is expected to affect some healthcare organizations. And then UBIT is imposed on certain fringe benefits. So taken as a whole, maybe more just sort of a disturbing precedent that Congress has expressed a willingness to be adverse to large exempt organizations. And in that regard, I'd note that just in the past few days, Republican Senators Grassley and Hatch sent a letter to the IRS asking the IRS to provide further information justifying the tax-exempt status of 501c3 hospitals. Of course, that's an ongoing saga that it was in part related to the so-called 501R rules, but that issue continues to be raised by members of Congress basically asking for justification of the exempt status of hospitals, so that battle continues. And this is one of the reasons why we perceive there being more risk of tax law change affecting tax-exempt bonds in this particular area than some other areas of tax-exempt finance, specifically because of this camel's nose under the tent.
And Mike, being a resident of Boston and being able to look across the river at several well-endowed institutions of higher education, there is sort of a perception by some in Congress, I think, that those endowments are fair game, and that's something that ought to be worrisome. The other point I make about this is that the 21% tax on incomes over $1 million. It's interesting because I saw a recent article in the Bond Buyer, depending on how the organization is structured, if there are a bunch of subordinate but independent organizations, that organization may find that it has quite a number, not just 5, but quite a number of officers who are being paid over $1 million. And so for each one of those entities, if they're not rolled up, you may find that you're paying 21% on.
Well, yeah, I think there's uncertainty about how a number of these provisions will be applied, and so my personal view, although I may be mistaken about this, is that these changes may be, worth disclosing in an OS, for example, but taken as a whole, I would guess they're usually unlikely to have a significant financial impact. But they do, more than anything else, establish a disturbing precedent. So moving on, there are, of course, changes to the charitable contribution rules. Some of them are actually favorable and some unfavorable to charitable contributions, particularly not listed here, the new exemption amounts for the estate tax could adversely affect some charitable giving. How that plays out remains to be seen. Um, the provision requiring UBIT to be determined separately for separate unrelated trade or business activities could actually, in our view, have an effect on corporate structures, and that is many organizations have operated within their exempt organizations activities that are treated as unrelated trade or business and been able to set off income from one trade or business or loss to another. But strangely now, if those activities were moved to a taxable C corporation, this offset could still occur. But if they remain in an exempt organization, they may not. You may get to a more unfavorable result. So we have the perception that this particular rule relating to a stricter way for how UBIT needs to be determined, the unrelated trade or business income tax, may result or prompt some consideration of the structuring of particularly healthcare systems, and that could have some ancillary, bond consequences if any of those properties are in part tax-exempt bond financed, but also just relating to corporate structuring. So I think there will be some transactional impact over time by this change. There are a number of sort of sleepers, I would say, in the Tax Act. One is a provision which basically clarifies the rules or creates more favorable rules for life insurance companies to acquire tax-exempt bonds. We don't have time to get into all of the technical details of how that provision works, but there is some perception that life insurance companies may be more interested in being purchasers of tax-exempt bonds than in the past. Whether that would have a major effect is uncertain, but it's something to keep an eye on. There are a number, of course, very favorable rules for taxable corporations, in particular, not only, of course, the lower marginal tax rate, but very favorable rules for so-called bonus depreciation for largely for equipment, and we don't have time to go into all the details, but it's possible that structures may be designed to enable 501c3 organizations to at least indirectly benefit in some manner from those rules. There are special rules that limit bonus depreciation for so-called tax-exempt use property, but there may be ways to navigate around that, in particular in the context of joint ventures between 501c3 organizations and for-profit entities. So in general, there are some very favorable provisions for taxable corporations that exempt organizations may indirectly benefit from. There is sort of a bigger question that's, I think, raised by this is, in the for-profit sector, one of the big questions that's been raised and subject to much discussion is whether the Tax Act will change the calculus for so-called choice of entity. That is, whether taxable businesses are in so-called C corporations, which are taxable corporations, or S corporations, or partnerships. But there's really a similar question raised in the big picture about whether some exempt organizations or portions of exempt organizations may want to migrate to be taxable corporations because the calculus has changed. After all, the penalty for being a taxable corporation is reduced. There are a host of other tax benefits. There may be a risk of tax law change. The UBIT rules are stricter. So that is an issue that we are working on and monitoring about sort of having ways to assess the calculus of which activities would be most favorably housed in taxable corporations as compared to exempt organizations. And that's part of the big picture of this Tax Act that hasn't really played out. So, any thoughts on that?
No, I think it's probably time to move to the CLE codes.
Thanks, Dave. At this time, I'm going to read the CLE code for this program. If you are in need of CLE credit today, please enter the 5-digit code in the poll question on the screen after it is announced and press the Submit button. The code is as follows: YL1NJ. That's Y as in yellow, L as in lion, the number 1, N as in Nancy, J as in jello. Again, if you're seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. For those of you seeking Kansas, New York, and New Jersey credit, in addition to the polling question, you will need to complete the attorney affirmation form and return it immediately after the program. A copy of the form can be found in the resource list widget. As a reminder, certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. Now wait a few seconds for you all to complete the polling information. At this point, the poll is now closed, and let's return to our program. I know, Mike and Dave, we have received one question so far related to the alternatives to tax-exempt advance refundings, and we were asked to describe an example of a make-whole provision as an alternative to no longer having advanced refunding options.
One observation I'd make initially about make-whole provisions is that they've come, which basically are intended to sort of, if bonds are redeemed early, to pay an amount that corresponds to the then market value of the bonds rather than a set 1 or 2% premium is basically the idea. So make them whole for the market value of their bonds, which could be significantly more than the 1 or 2% premium. One observation is that they've commonly been used for taxable bonds, but have been less common for tax-exempt bonds. And one reason, in my view, they haven't been used as much for tax-exempt bonds is that if bonds, under the prior rules, when we could do advance refundings, you'd have to be able to take bonds out at the first date, the first call date on which there'd be savings. And there have been many problems about how that rule is interpreted with a make-whole call provision. So one reason they haven't been used is that there's been some perception over the years that a make-whole call provision could make an advance refunding impossible in the future of that bond, but that's not going to matter anymore. So it may be that now that bonds can't be refunded on a tax-exempt basis, and we don't have this particular rule that requires bonds to be called out as soon as they can, that we'll see more make-whole call provisions in tax-exempt bonds than we have in the past, because one of the consequences of make-whole calls that discourage their use has been removed.
I think that's a great observation. Dave, anything to add to that point?
No, the one thing I would add is that it may be that what we'll see is make-whole call provisions for what would have been the lockout period, so that if a borrower wants to get out from under the bond issue in the first, say, 5 or 10 years, that they can do it through a make-whole call, whereas after that there will be a regular optional redemption at any time, in whole or in part, at 100. That may be a compromise that at least some borrowers will give a shot to see if that gives them a little bit more flexibility.
Mike, I know we I wanted to circle back to some of the ancillary implications, and the one bigger picture question you raised concerning whether the Tax Cuts and Jobs Act will prompt some of healthcare systems to restructure their mix of tax-exempt and taxable corporations. I think that is a very interesting question, and certainly you could envision a situation where, and I'm not thinking necessarily some of our larger religiously organized healthcare systems, but perhaps some of our tax-exempt community-based systems could, as a result of, the Jobs Act as well as the peeking under the tent that you alluded to, you certainly could see some tax-exempt corporations perhaps reevaluating the benefits to being a tax-exempt corporation, because certainly with the Jobs Act, in connection with, I think, challenges to property tax exemption, labor challenges as well, or union activities. There does seem to be a developing theme concerning tax-exempt corporations, and are they providing the value added relative to the benefits that they're provided? So I think it's a very interesting, bigger picture question, and probably appropriate for certain healthcare systems and not appropriate for others.
Right, and one question is the greater use of joint ventures, or basically structures that interact with for-profit corporations or joint ventures with for-profits. So you mentioned community hospitals. I just mentioned we didn't talk about it in our slides, but there are still basically favorable tax provisions in the code that have been enhanced for distressed communities. So the new markets tax credit has continued, and indeed there are new provisions for so-called opportunity zones, which basically provide that some of the gain that businesses have in opportunity zones, which will be designated shortly, but they're basically low-income areas, can receive special tax benefits. So, another question we've been looking at, is are there ways for, exempt organizations to coordinate, either their own for-profit entities or other for-profit entities with some of these very favorable rules that are actually now in this Tax Cuts and Jobs Act, which could prompt some structuring and also some transactions that haven't been entered into in the past. So for the community hospitals, in particular the opportunity zones, may be something that could be considered as, how can at least indirectly hospital systems take advantage of those rules? Because often, many hospitals are in distressed areas that might be designated as opportunities. There might be some unique opportunities there.
Well, I think that's a great question to end on. We would like to thank our participants, and certainly I'd like to thank my fellow speakers. We invite you to contact any of today's speakers if you have any additional questions or would like more information on the particular topics. This wraps up today's web conference. Just as a reminder, today's program was recorded and will be available on Foley's website in the next few days. At the conclusion of this program, a questionnaire will appear. Please take a minute or two to give us your feedback on the presentation today. It's important to us to know your thoughts, and it helps us shape our programs going forward. If you have any questions regarding this program, please contact Kristen O'Neill at KONEILL@Foley.com. Thank you again for your participation.